Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Good afternoon and welcome to the Southwest Florida Real Estate Update. I'm Michael York with the York Real Estate Group, and I'm joined today by our host Jim York and his guest Don Ross of Ross Title and Escrow.
Thank you, Michael, for the introduction. Don, well, welcome back this month again for our legal tip. For the viewers that have not heard of you or seen you on the show before, could you just tell us a little bit about yourself?
I'm a practicing attorney here in Naples since 1982, primarily real estate. 8 people in my office doing real estate closings, own Ross Title and Escrow. I'm a shareholder in Downing Fry Realty. Have a degree in taxation, which comes in handy with our foreign clients, buying and selling. Do a fair number of closings, and obviously for quite some time.
I think you told me 30,000?
20 to 30 somewhere. I tried to count and got within that range. So,
hey, and tell us a little bit about your team down there and where your location is.
We are on the corner of 6th Avenue North and 41. It's the Capital Bank building across from Pastrami Dan's. Most of my ladies have been with me for a long time. I manage her 28 years. I have various members of her family. We've got 4 closes, 2 pre-closes, post-closer, several bookkeepers. God bless the Dodd-Frank Act. We have several bookkeepers.
Right.
Good team, been together a long time.
Well, today, Don, we've gone through contracts. We've done a lot of things over the last months for you being on the show. But what I thought today would be unique is to go over some things that are coming up when people have a real estate transaction.
Sure.
And questions that somebody might ask or occur. One thing is there's a lot of fraud right now with people giving checks or wiring for closings or deposit. Maybe explain how people can avoid that.
Well, there's been a lot of fraud going on for a long time. What I tell my clients is that, well, this is a very wealthy area, and the crooks of the world are attracted to where the money is. You have a lot of widows who may not be able to recognize the fraud. It comes in all shapes and forms. Right now, the big thing that has everybody excited is wire fraud. To answer your question, how or what they can do to avoid it, use a realtor that they know and trust. Have the realtor recommend, the particular attorney or title agent. Have the client contact that person directly. They can Google the person if they want, and then have the attorney or title agent wire their own or email their own wire instructions out. We send with our opening letter to the seller and to the buyer wire instructions. We ask that they initial it. Whatever wire instructions we get from them, we ask that it be initialed. Our underwriters require that if there's a change, that we call and verify that that was them and it wasn't somebody who hacked into the seller or buyer's email, because that happens a lot.
That's right.
They actually hack into the seller's email, that might be the agent's email, and impersonate them at the last moment. So there's a lot of telephone calls and confirming. I actually have insurance for it, believe it or not. It just came out, this new product.
Oh, really?
So it's that crazy. We've gone through that. Fraudulent cashier's checks, overseas checks, promises to purchase from non-residents based on a foreign check, which never clears. Your bank might give us access to it, or my bank might give us access to it, but it doesn't clear. They might have an internal policy on giving us access to it, and then if it bounces down the road, I have to make it good. So we require wire instructions. We are vigilant in talking to the client, and if there's a change, calling, is that you? And making notes to the file, and on top of that, getting insurance for it.
And another question that comes up a lot is people are getting a mortgage.
Right.
And they have a mortgage contingency. Sometimes it's 30 days or 45 days. After the 45 days is up, what basically happens there? Because the seller probably wants to get that lifted, right?
Oh, yeah.
Okay, so maybe explain people's options or buyers' options or sellers' options to that.
I'll address it with the Naples Board of Realtors contract.
Right.
That's the one just before the show I was discussing with your son. That contract calls for a waiver from the buyer. There's a lot of confusion over that. Some people think that if the buyer does not waive the financing contingency, that they are in breach of the contract. They're not. If they don't waive the financing contingency, it simply gives the seller and buyer other options. The seller has the right to terminate the contract and sell it to somebody else. The buyer would get their deposit back in that situation. The buyer, if they get a letter of adverse determination, it's referred to in the contract, it's a turn-down letter in regular English, they have the right to terminate and get their money back. What I look for is, did they apply for the loan that's outlined in the contract?
Right.
If the contract calls for an 80% loan, did they apply for an 80% loan, or did they go for a 90% loan?
Okay.
You know, did they change the type of loan they're going for?
Terms.
Did they make a good faith effort to get the loan? Did they supply all the tax returns and so forth that are required by the lender?
Right.
This ties into a common theme in all our shows, the importance of a team and the issues you run into when you use an out-of-state or even an out-of-town lender. The case I was discussing with your son, it's I believe it was up in Tampa.
Right.
And if they're not part of the team, if it's not somebody you've done 100 closings with,
That's right, yep.
and you don't have their cell number, you just don't know where they stand. Now, the way I explain it to my buyers, if you're going to consider waiving the financing contingency, what you're really doing, it's a business decision. You're looking at, you don't want to lose the property.
No.
And what you're weighing is, if I don't waive this, I could lose the property. If I do waive it and something happens with the lender, like in Michael's situation, I think the underwriting person was on vacation or sick or something.
That's right.
If you do waive it and the bank drops the ball, you lose your deposit. So what's more important, your deposit or the deal? And the buyer has to make that call, because you or I don't know the buyer's financial situation, whether they have backup money in the bank where they could pay cash, whether they make $1 million a year and will have no problem, whether the banker is their brother-in-law, we don't know. We don't know what was on that application, so we're not privy to that. So I say, this is your call, Mr. Buyer. If you've dealt with this lender 1 million times, you're comfortable, you have backup money, and you don't want to lose the deal, go ahead and waive it. And in fact, I'll call you and I'll ask, have there been other offers? Do you think the listing agent has got another offer in his or her hip pocket and they're trying to get rid of the buyer? Sometimes they try to do that. So I think that answers the question.
Yeah, that was very good. Don, we're going to take a little short break here, and we're going to be right back in 1 minute.
Thinking of buying a home located in a golf course community in the Naples, Marco, Bonita, or Estero, Florida? Here is what Mark Lai, former PGA winner, says about Realtor Michael York of the York Real Estate Group of Downing Fry Realty.
Hi, I'm Mark Lai. If you have any real estate needs in Naples, Florida, the one company to contact is the York Real Estate Group. Also, if you want a golf course property to invest in, Michael York of the York Real Estate Group is the guy to contact. Michael knows every golf course in Naples. I will tell you this, he's been in the golf business for a long time. He's played all the great golf courses down here, and he is an outstanding realtor. I've known him for quite some time, and he's honest, he's got a lot of integrity, and he very much knows his stuff on all the different clubs here in Naples. So the York Real Estate Group is a great place to start. So if you have any time or anybody that wants to visit down here in Naples and look at the options out there, please contact the York Real Estate Group.
Welcome back. Don, let's take it, somebody buys a property and they didn't realize the garbage disposal chute, I guess the garbage chute outside the condo is right outside the door, and it makes a lot of noise when people go there and they put their garbage down the chute. Does the buyer, after they close, have any recourse against the seller if they didn't disclose that?
No, not any. I mean, the law is seller must disclose a latent material defect, and I know we've talked about this before,
That's
but
right.
it's not latent if it's right there.
Mm-hmm.
You walk right by it, it's right there. It's not a material defect if it doesn't affect substantially the value of the property.
Right.
And I seriously doubt a garbage chute would do that. So, the short answer, no. I mean, if they lie about something on a seller's disclosure, that's a whole different type of liability.
How about if somebody's got a neighbor, okay, and the neighbor is bipolar, a little wacky, and has caused some problems in the community or with the other neighbors, and person sells the house, and then the person that buys it later finds out about that. Is there any recourse on that?
No, and it's amazing. I get questions like this regularly from agents.
Mm-hmm.
Some of the situations are just, if they weren't serious, they'd be hilarious.
Right.
The neighbors fight an awful lot and they make a lot of noise. Don, do I have to tell the buyer? Well,
Right.
you're in slander territory
Mm-hmm.
at that point. I mean, they might be within their legal decibel limit.
Right.
There's been no crime or anything.
Mm-hmm.
It's a slippery slope. So you stick to things affecting the property. You don't lie in your seller's disclosure, and the things affecting the property cannot. It has to be something that would affect the value.
Mm-hmm.
I mean, I've had bipolar neighbors. I've had neighbors who fought. I had people who would go out and whack a rubber tire hanging on a rope with a
That's
baseball bat. Do I have
Right.
to disclose that? It's better than watching Judge Judy, some of the questions. I mean, but the answer is no.
Okay. How about if somebody has a relative, okay, and they've put furniture in their house,
Mm-hmm.
and the relative dies? Doesn't necessarily have to be a relative, it could be a friend.
Mm-hmm.
What recourse do they have to get their furniture out of the place or not?
Well, you gave me certain questions before the show, and that
Right.
one I read, and there's
I'm glad you read one.
I read one. Yeah, what I would do and what is legal are two separate things. I hate to say it, but legally you need permission from whoever it is to trespass. My son owns a house in Virginia, and he has shrubs along the lot line, and I was up there showing him how to work the trimmer.
Uh-huh.
And to get on the other side of the shrub, you had to go on the other person's yard.
Right.
And I said, it might be a good idea just to knock on the door and introduce yourself and say, hey, I'm trimming this shrub, just in case they're crazy about what the shrub looks like.
That's right.
And you're walking across their yard. So technically, you're supposed to ask permission. If I had furniture at my parents' house and something happened to them, I'd just go get it. But I'm their power of attorney too, so I can get away with that. But going into a stranger's house, you're opening yourself up to charges of trespassing and perhaps stealing.
Another question that we had here was, husband and wife, I guess maybe it wasn't a husband and wife, he put the money up for the house, okay, and she didn't have good credit, and that's one of them, put the mortgage, and he didn't have good credit, but she had good credit, but he put the money up, and then after they closed on it, they had a argument, and how do you resolve that problem?
You really can't. I've had this happen to me. I've also had people who bought multi-million-dollar condos and asked me to please put their girlfriend on the deed. And fortunately, when that happens, it's usually somebody I know pretty well, so I can just call and say, really? You sure? How long you guys been dating? This person will own half this condo. It's a gift. So you have to be careful. There's a point where you want to do your job, I want to do my job, but you don't want to get too intrusive into their personal life. You don't want to question the validity of a relationship. So I always ask, well, I explain to them the significance of co-ownership, and that person owns it. So if you've only been married 3 minutes, and say, well, just pointing out the obvious, the divorce rate is 50% for first-time marriages. I'll do what you ask me to do, but I feel like I'm not doing my job unless I point that out. Probably the safe thing for a realtor is just to put that on the attorney.
Yeah, that I would suggest.
Because it's a very personal thing
Right.
you're getting into, and you have to be careful how you do it.
And there's another question we have here is about easements. Okay, you know, who takes care of the easements? If there's a big tree that's, you know, obstructing or the house or whatever, who'd be liable for that?
They're actually two separate things. The good book here, I have 20 pages on easements, which I won't bore with you with right now, but you get a lot of people whose landscaping grows and it starts to hang over the neighbor's yard.
Right.
And there is, I think it's a 3rd district case, we're in the 2nd district, that says the person over whose home the tree is hanging can trim that tree. They have the right. It's on their property. They can trim it. If the tree falls on their roof, the person who owns the other lot where the roots are is not liable for that damage. Now you have the practical problem of this is your neighbor.
Right.
And it might be some prized Japanese tree that somebody's grandmother, I mean, I have a home that my grandmother planted some of the things in my yard. So prudence would dictate that you at least knock on the door and say, you know, do you mind if I trim that tree? I'm just going to do this much. I'm hiring a professional. You know, I have the legal right to do so, but I want to be a good neighbor, just so that you stay on speaking terms. But in a nutshell, you have the right to trim it. If it falls in your house, the other neighbor isn't liable. But maintaining a good relationship, I think, is important.
How about daughter, husband, and father buy a property together?
Ironically, I had this conversation with my daughter, who she should have a chair, I think, right here. She's on this show all the time. And I spoke to her maid of honor this morning about that exact situation. And I told her, because you're my daughter's best friend, I'll just tell you what I told my daughter. There's no way in God's green earth that I would ever permit my daughter, as if I have control over it, but if I have any control, I would never allow that to happen. You know, if it's a parent with, you know, a child and boyfriend, girlfriend, or a spouse, you know, again, you have the divorce issue. Is that money you can afford to gamble? Is there another way to do it if they're already married? You could get a mortgage. You know, you can give a mortgage. You're going to have it qualified now because of the Dodd-Frank Act. You know, run it through part of your team, Kevin, in that case, and qualify the financial wherewithal of your daughter and, say, her husband, if she were married at that point. And then you just give them a loan so you can maintain an interest in the property and make sure payments are made. They can be nominal payments. It could be 0 interest. You can forgive a portion of the loan each year they're married. There's all sorts of things you can do. But newlyweds, if it's beyond just putting a deposit down, I would run it by a lawyer and see how you can protect it and just make sure that the relationship is stable.
Well, Don, we're going to take another little short break here, and we'll be back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over 250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Don, let's stick on the easements, okay? If you have an existing structure that's on an easement, well, how do you resolve that problem?
It comes up quite a bit.
Does it really?
It really does. Fences, you know, they might meander a few inches onto your neighbor's yard. You might have part of a deck that you built, and it sticks into part of your neighbor's yard. What we do is recommend, again, I'm always thinking of not just a legal issue, but what's best for the client. You don't want them starting World War III with their brand new neighbor, yet you want to protect their property. So there's a thing called a revocable license agreement. It's what you get when you go to the movies. It's what you get when you go to a baseball game or a football game. You don't have an ownership interest in that seat. You just have the temporary right to sit there, and if you misbehave, they can tell you to leave. So we do a revocable license agreement that shows the survey, shows where the fence is sticking into the property we're acquiring, and we have the neighbor sign it, conceding that yes, his fence sticks 3 inches into this person's property. He's not claiming any ownership interest in that property. He will remove it if he's asked, and that is sufficient. It maintains good relationship with the neighbor. You might actually like the fence. I mean, you know, it might be a lousy survey, which happens.
It does happen.
It happens quite a bit. So you go to the neighbor, you say, look, the lawyer's making me do this, so you always blame me. You could even bring a bottle of wine over, but you get something in writing conceding that, yes, my fence is sticking onto your yard, and I don't own that portion of your yard, and I will move it if you ask me to. But, you know, orally, your client is telling them, you know, I'm fine with the fence. You know, if and when I ever sell the house, they may have a problem. So that's really when it would only come up. So that's the revocable license.
Another question that maybe the final question here is that have had problems sometimes with people or other real estate agents, that you know, my buyer is buying a property, and you're supposed to disclose what the condo fees are, and there's a disclosure for that. And sometimes they don't want to give that to us. How would you handle that?
Yeah, this is I write articles for the agents in our company, and this is actually the one I'm going to write this weekend. Difference between homeowners associations and condos and what you have to give or not give. A lot of confusion out in the public. All you have to give with condos, all the seller is required to give pursuant to the statute, pursuant to standard H, I think is in the neighbor contract, is a copy of the declaration, the bylaws, the articles of incorporation, rules and regulations, frequently asked questions, a document called the governance form, and a year-end financial statement. I mean, that's it. There's no one-page disclosure required that gives the maintenance fees. I put it on my buyers, say you're going to fill out an application to be approved. Ask the management company. You know, you're going to have to go be interviewed, probably on the phone anyways. You can ask that, and you can also ask any questions that are ambiguous. You know, after looking at the frequently asked questions, we focus on the use restrictions in the declaration and the year-end financial. And usually I look at those for the client. I use these little stickums, and I'll tab them and say, this is what I don't want you to miss. I'm covering myself here.
But on MLS, I'm talking about the quarterly fees or the monthly fees. You know, they have it on there, whatever it is, $800 a quarter. So you're saying that by law they're not required, the seller to...
The seller's not required.
Okay, so they could have the wrong information on there. And
They
the person
could.
buys a property and then ends up figuring finding out later that it's $1,200 a quarter, what recourse do they have at that point?
Well, they
The
can
buyer.
go. They can go and pursue the seller, and it's going to come down to where did that information come from? Did the agent come up with it?
Right.
Hopefully not.
Right.
Hopefully there was an email from the seller to the agent saying this is what the maintenance is.
Okay.
And you, if you're the listing agent, you put it in
Right.
MLS.
Uh-huh.
You know, you want an email, something from the seller saying these are the fees.
Okay.
They filled it out. It's their handwriting.
Right.
You know, you're just a conduit putting it in MLS.
Okay.
I mean, I've had this with cable bills, where
Right.
it's a $13 discrepancy, and,
Right.
and they want the next 20 years worth of
know.
the discrepancy.
Yep. Mhm.
And they do have the 3 days after they receive all their documents to do whatever investigation they want, to look
Right.
at the year-end financial, and oftentimes they get the budget too. It's
Right.
not legally required.
No, but they do get
But
it.
they get
Right.
it, and hopefully it shows it. I looked at, before I came here, frequently asked questions for the Carlisle in Pelican Bay, monthly $1 million condos, and it actually had the maintenance fees in the frequently asked questions.
Okay.
So that made my life a little easier, and fortunately, because the buyer is an attorney from Chicago,
Right.
so I can, you know, it'll be crystal clear to him.
Well, Don, I appreciate you coming on this month, and
Thank you.
I think this has been very helpful for our viewers and
I enjoy it.
people that we're associated with in buying and selling. So
Thank you.
again, we'll see you next month, right?
Absolutely.
Okay. Well,
Thank you, Jim.
thank you very much.